Good day, ladies and gentlemen, and welcome back to another What If video. Today's topic is, what if an employee is too sick to attend work but well enough to attend a rugby match? Now the question is, what can employers do when an employee is on paid sick leave and consequently too sick to attend work but well enough to attend a sporting or social event? Can you take disciplinary action, and if so, can you even dismiss the employee? Or is it a case that where an employee is booked off, what he or she does is not the business of the employer? Now the case I want to discuss is the matter between Woolworths versus the CCMA and others. It's a Labour Appeal Court matter, and the judgment was delivered not too long ago in December last year. Now in this case, the Labour Appeal Court considered the consequences that flow from an employee being too sick to attend work but well enough to attend a rugby match, all while enjoying the benefit of paid sick leave. The facts of the matter is the following. The employee contacted and informed his manager that he won't be able to attend work due to him being sick. It so happened that on that same day he phoned in sick. During paid working time, he travelled 80 kilometers between cities to attend a sporting event with his father. The travel duration was approximately 1 hour, whereas the employee would only have had to travel 20 minutes to get to work. The next day, the employee reported for duty, and during a conversation with his manager, he admitted that he attended a sporting event. He, however, claimed that he had recovered from his illness before he went to the sporting event. The employee was then charged with misconduct. He was found guilty of breaching company policies and procedures by abusing the authorized sick leave for which he had been paid, and he was subsequently dismissed. He believed his dismissal was unfair, so he referred an unfair dismissal dispute to the CCMA. And the CCMA arbitrator or commissioner agreed with him. The commissioner found that the dismissal was procedurally and substantively unfair and reinstated the employee with full back pay. The arbitrator concluded that the employee was not charged with dishonesty and therefore the trust relationship had not been broken. A very interesting approach to take. Furthermore, the employee did not try to hide the fact that he attended a rugby match while he was on sick leave. In addition, the arbitrator found that no evidence had been led about any previous warnings that were issued to the employee in this regard. The employer was not happy with this arbitration award and took the matter on review. On the review, the Labour Court held that the company had failed to prove on a balance of probability that the employee acted dishonestly or that there was a policy in place that required employees who had been booked off sick to return to work when they feel better. The Labour Court accordingly agreed with the CCMA that the dismissal of the employee was unfair. The employer was not happy with that and then took the matter on appeal, challenging the Labour Court's decision. The Labour Appeal Court on appeal held that the employee had admitted that he was dishonest. It was dishonest of him to be paid for that portion of the day that he attended the rugby match. The employee also admitted that his conduct did not set a good example for his subordinates. The Labour Appeal Court found that while the employee was not specifically charged with dishonesty, he acted dishonestly in absenting himself from work on the basis that he was too ill to perform his duties, but then travelled for at least an hour to support his local rugby team, knowing full well that he would be paid for the day. Now, in considering the order of reinstatement on the basis that the employee's conduct did not render a continued employment relationship intolerable, the Labour Appeal Court found that this lenient approach to dishonesty cannot be tolerated. And that's a welcome outcome of this matter. The court said that the employee was employed in a relatively senior position. He confirmed that his behavior was not a good example for the subordinates or his subordinates, and he was patently dishonest in that he expected to get away with enjoying a rugby match while enjoying the benefit of paid sick leave. The court held that it was this dishonest conduct that negatively damaged the trust relationship. The Labour Appeal Court further found that it was manifestly justifiable for the company to adopt the approach that the employee was required to act with integrity and abide by company's policies, procedures, and codes. The court found that it was clear that the trust relationship had been broken down and that dismissal was an appropriate sanction. What is welcome of this judgment, ladies and gentlemen, is that the court said that the CCMA and our courts should approach dishonesty offences with common sense, and where there's evidence that the trust relationship is broken down, dismissal is, generally speaking, justified. Now that brings us to the end of this video. As always, thank you for watching. Until next time, bye-bye.